Here we
Hi, everybody. Thanks for joining today. So I have I'm just going to go ahead and start with some hard news. This is not the most sexy and exciting of topics, and nothing I can think of short of dancing, which you don't want to see, will make it that way. And it's also pretty nuanced and hard to understand. So, for happy afternoon, some hard stuff that's kind of boring, but very important for a lot of you to know for your future status on H-1B. So discussing H-1B employment-based non-immigrant status today, and I'm going to start by giving you my information. So this is my contact information. I cannot, if you go to our website, which is listed, you can get my email address or you can submit a question through the website. So if there's anything that you're, ruminating on when you can't sleep tonight and, you want to run it past me, feel free to share any questions that you don't think were covered today. I can't answer anything that is specific to your situation. So just keep that in mind in your questions today, that the questions should be general to the topic and not specific to your particular situation. So the first thing we're going to start off with, what is an H-1B? So an H-1B is a non-immigrant, which means temporary status, and it's a specialty occupation status. So really, this is sort of how most people are in the United States in professional positions. So it's sort of our standard professional work visa. So I'm listing up top the laws that govern the H-1B status, which you probably will never look up and you probably should never look up. That's fine. But if for some reason you ever wanted to dive deep, you can take a look at those. Basically, what a specialty occupation is, to get an H-1B, you have to be offered a job in a specialty occupation, which means a professional job where the duties of the position are too complex to be performed by someone who does not hold a 4-year degree or its equivalent. So what that means is that all of the duties of the position have to be professional. So when I say all of the duties, what I mean is sometimes there's a position that might be partially, so say it's like a accountant / bookkeeper. So it's more or less an accountant position, which would be a professional occupation, but some of the duties might be say bookkeeping, which is not a professional occupation, then you sometimes run into problems. So that's something to sometimes watch for, particularly if you take an H-1B with a small company where the job duties aren't as defined or split into small pieces like that. So you have to make sure that all of the duties are professional. And then you yourself, in addition to the job requiring a bachelor's degree, you yourself must hold at least a bachelor's degree or higher in a field that's directly related to the job. And that's a tricky point in H-1Bs too. What that means is that it's sometimes very straightforward. If you have a mechanical engineering position and you have a mechanical engineering degree, that's very straightforward. But sometimes some positions are not that straightforward. You might have a therapy position where they would take someone with a social work background or a psychology background or some other type of background. That's going to be harder for a specialty occupation because there's not one particular degree that's directly related to the position. So that's something that the employer might have to argue, is that your degree is very specifically related to the position and that they typically hire someone with your particular degree for that job. And finally, of course, if the professional position requires a license, so it's something like a doctor, a lawyer, a teacher, a pharmacist, you have to have a valid license. The exception would be that if your licensing board wouldn't allow you to have a valid license until you had an H-1B or some other status, then they would let you wait until you had the status to obtain the license, but that's a rarity. So this is where the H-1B gets fun. There is something that we would call the H-1B cap. And basically, all H-1B petitions are either subject to the cap or not subject to the cap. Whether or not you're subject to the cap is based on the type of employer that's filing for the position. Most employers are subject to the H-1B cap, and we will discuss which ones are exempt. If you're subject to the cap, what that means, what the cap is basically a quota. It's a per fiscal year quota on H-1B. So there's not an unlimited number of H-1Bs. There's 65,000 total H-1Bs available, plus an additional 20,000 that are set aside for individuals who have a master's degree or higher from a U.S. institution. So if you have a master's degree or higher, it doesn't mean that the job has to require that. So you could be in a job that only requires a bachelor's degree, but you have a master's degree. That's okay. You would still count against the master's cap. So basically, it's intended to give a better chance. The way the selections go is that, the people who have a master's degree have a better chance of getting drawn in the lottery than people who don't have a master's cap. So when I say the lottery, what I mean is that every year, because there's the limited number of H-1Bs, there's a time period, which tends to be at the end of March, where employers, and I said here as of fiscal year 2021, employers register with a government system. So they actually can register maybe as early as January. It does vary a bit from year to year. Every year, this program has some slight changes. But generally speaking, as of 2021, the employer will kind of go online on January 1st or somewhere in there and register within that system if they've never filed an H-1B before. If they have, then they don't have to re-register. And so they register, and then they submit your information as saying as of mid-March, they usually submit whatever employees they want to be selected in the H-1B cap. So these are the people we want to sponsor for an H-1B in the next fiscal year. And then the government accepts those applications for a short period of time, generally a week or 5 days. And then they see after 5 days, they see, do we have enough applications to meet the quota? And they always do after the initial 5-day period. And then they close the registration and they take all those applications that they received during that 5 days, and they make the selections of which cases will be processed. So when you're selected for the H-1B cap, it does not mean that your H-1B is approved. It only means that you're selected for further processing so that your employer can then move on to actually submitting the H-1B petition with USCIS, and then that will be adjudicated. So it doesn't necessarily mean you're in. Your odds of getting an H-1B are really generally around 50-50 or less than 50%. So it's a little troublesome, right? Because you're sort of basing your whole career on, you're generally going through F1 and then OPT, and then you're moving on to the H-1B, and you're hoping to get one of those, and you have essentially a 50-50 chance of getting one. There are a couple notes here. There are some other, in addition to the 65,000 that are normally set aside, there are some additional agreements, free trade agreements that the United States has with Australia, Chile, Singapore, that add numbers into the cap. So they're basically processed very similar to H-1Bs, but they generally don't meet the cap. So if you're fortunate enough to be a citizen of Australia, Chile, Singapore, then there still is technically a cap for you, but because you would be applying under these free trade agreement sort of byways, then you wouldn't actually probably have a problem with meeting the cap. So the government's fiscal year runs from October to September. And in general, you can file for an H-1B 6 months in advance. So the reason that this cap season starts in March and the filings start in April 1st is because the earliest you can file is 6 months in advance of any particular start date for an H-1B. So they're saying if you're selected, you can start filing on April 1st, but the earliest start date that you would have is October 1st. So as a, for instance, we're kind of in the middle of H-1B season right now, which means that anybody that was selected for fiscal year 2023 was just selected. They can file, they have a 3-month filing period. So they can file, if they were selected, they can file between April 1st and April, May, or June, and to the end of June. And then they're then their start date would actually be October 1st of the earliest it could be would be October 1st of 2023, which is or 2022, which is the first fiscal year, the first day of fiscal year 2023 for the government. So the question always arises, of course, what happens, first of all, if you're not selected for the H-1B cap? So if you're not selected, then you may or may not be okay. You may run out of it. You may run out of OPT time, and then you may have a problem. But some people are, as you probably know, eligible to extend their OPT. So OPT, optional practical training, is a 1-year period of free work authorization that's essentially given to an individual at the end of their degree program, each degree program. So at the end of your bachelor's degree, you get a year. At the end of your master's degree, you get a year. And your PhD, you get a year. And it's sort of free work authorization so that you can have experience being employed in your field. If you are in a STEM designated field, then, and you'll know that from your I-20 for your F1 status, then you can extend your OPT for an additional 24 months after the first year. The reason that was initially put into place was really to give individuals with STEM degrees an advantage in getting H-1Bs, because you presumably have 2 or 3 H-1B cycles that you can apply for, depending when you graduate. You have 2 or 3 H-1B cycles that you can apply for. The other question that comes up frequently is, let's say my client applies on April 1st for an H-1B and it's approved. They file by premium processing, which gives us a fast answer, and they're approved at the end of April. But their H-1, so that means that their H-1B time will start on October 1st, which is the earliest it can start. What if their OPT time ends in, say, August, in between the time that it was approved and when it actually starts? In that situation, there is something called OPT cap gap, and that is a measure that USCIS put into place to allow people to have automatic work authorization. So basically an automatic extension of your OPT if you have an H-1B approved, but your OPT expires before the H-1. So you were in OPT status when it was applied for, but it expired prior to the beginning of your H-1B on October 1st. Then you have automatic work authorization to cover you during that time. So that's nothing extra that you have to apply for. That's all automatic. And your employer will just need to note that on their I-9. And then I did mention that some employers are not subject to the cap, and we will talk about that next. So basically, it's nice when employers are not subject to the cap, because then you don't have to worry about all of this. You don't have to worry about the lottery and will you be selected or won't you, and limits on numbers. So employers that are not subject to the cap can apply for an H-1B at any time of the year, and they can also have as many H-1B employees as they want, so they don't have to worry about that. So situations where people would be not subject to the cap. First, there's institutions of higher education. So universities and colleges are not subject to the H-1B cap. So that's probably the biggest exemption. So U of M, for instance, can apply for H-1Bs for individuals at any time of the year and not worry about the cap. There is a common misconception that all nonprofits are exempt, and that is not true. Only nonprofits that are either research or government research institutions. So that means that the primary purpose of the organization is research, or it's a government research institution, or a nonprofit that is related to institutions of higher education. In that case, only in those situations would nonprofits be exempt from the cap. The other thing, and this is the top point here, is that if you have been counted against the cap and you subsequently file for another H-1B, say with a different company, so a change of employer H-1B, you're not subject to the cap anymore. So the best way to think of it is you're only subject once. So if you have already been counted against the cap, the next time you apply for an H-1B, you're not subject to the cap. So in terms of just some basics of the status, H-1B status is issued for a maximum of 3 years. The employer can ask for less than 3 years if they want to, but they can't ask for more than 3 years at a time. They can file extensions as necessary up to a maximum of 6 years total. So you have 6 years total in H-1B time to work with. There are some exceptions to that. There are some situations where you can have more than 6 years of H-1B time. That can happen in the case of if you've been outside of the US for more than a year. So if you get H-1B status and you work for 2 years and then you leave the US for a year, that will reset your H-1B clock back to 0. So you'll have 6 more years available. But the bad news is that also resets the cap. So that means that you would once again be subject to the cap. So that's probably a plus minus situation. It's also helpful to know that any time that you've spent an L status can be counted against H status and vice versa. Probably none of you are subject to or have been in L status, so that's intercompany transferee. So if that's the case, that can potentially count against your H-1B time. Seasonal or intermittent H-1Bs, the short way to say that is sometimes you might have an H-1B with a company, but you don't actually spend all your time in the US. Maybe you come in either on a seasonal basis or you only come in once in a while, like you only come in like 90 days a year or something like that to work. Or if you spend less than 6 months of your total time in the US in any given year, then you can extend the H-1B indefinitely. So it really doesn't even have a time limit. As long as you don't spend more than 6 months per year in the US. And that's very helpful in this day and age to know because a lot of people are working remotely. Additionally, you can recapture any time spent outside the US. So what I mean by that is when I say there's a 6-year limit on H-1Bs, that's only time that's physically spent in the US. So if you spend every summer at home in your home country, you can, when you get to the end of that 6 years, you can sort of look back on the dates that you've spent outside the US and you can reclaim those. You can add those back into your time. So any time spent outside the US should be tracked because you can add it back in at the end if necessary. There are also other ways that you can have 7-year plus extensions. So what I mean is you can extend past the 6th year if you have a green card pending. So if you start the green card process and you have the first step toward that process filed by the end of your 5th year in H-1B eligibility, or if you have the I-140 part of that employment-based green card process approved before your H-1B status expires, before the end of the 6 years, in one of those two situations, you can extend the H-1B based on the pending green card. As for your dependents, they can, when I say dependents, I mean only spouses and minor children can have H-4 status. Children up to 21. H-4 status is not automatic. So you have to separately file for your spouse's H-4 status and you have to separately maintain it. So when you're extending your status, you have to make sure you separately file an extension for your spouse and children to make sure their status is covered as well. So kind of separately look out always at their deadlines and expiration dates, which should mirror yours for the most part. But there are some situations where theirs might be a little different than yours. So you'd want to watch their expiration dates carefully. And generally speaking, H-4s are fairly limited in what they can do in the US. You can go to school, but it's a little different than F1 status. You can't be employed on campus like you could be in F1 status. You don't get OPT, things like that. But aside from that, they can't be employed until green card I-140 is approved for the H-1B holder. Then they can apply for work authorization. But generally speaking, there's no employment and there's not a whole lot they can do. It's a fairly boring status. So in terms of things you should be careful of, one is I do get a lot of calls from people who or employers who say, oh yeah, we want to hire someone who's already on an H-1B. So all we need to do is have an H-1B transfer. So H-1Bs are employer specific always, all of them. They only allow you to work for that employer in that particular job. So switch to another job, that is possible to do, but there's no such thing as an H-1B transfer. It doesn't mean there's some, what I mean by that is there's no simple process to just fill in like, yeah, I'm with this other employer now. The other employer has to start over. They have to file a whole new H-1B for you, a whole new petition. So, that does need to happen. One advantage though is they can have you start the new position as soon as they file the petition with USCIS, rather than having it be approved. So usually employers will want to see it approved anyway, because they don't want to take that risk that ultimately it wouldn't be approved. But if you're in a pinch, you can start right away when the petition is received. One thing you have to be careful of is if you went from a CAP exempt to a CAP subject employer. So if you were with the University of Michigan and you decided to go work for Ford Motor Company, remember, you haven't been counted against the CAP, and everybody has to be counted against the CAP once, right? If they're going to a CAP subject employer. So then you would be subject to the CAP, even though you didn't have to worry about it the first time around. The opposite would not be true. If you were going from a CAP subject employer to another CAP subject employer, as I said, you've already been counted, so you don't need to be counted again. It's also really important for you to keep in the back of your mind, ultimately, this isn't your responsibility, but it's important for you to know that any changes in your job or work location might require an amended petition to be filed prior to you starting that new position. So if you're with an employer and they want to, move your job from Michigan to California, or they want to substantially change the position that you're in, it might be that they have to file a new H-1B prior to you starting those changes or moving. If it's a normal thing within if it's just, you're being promoted, but it's basically the same job, or you got a raise, that's fine. That does not have to be reported until the employer files an extension. But if they're making a major change to your job, they do need to report that and file an amended petition with USCIS before you change that position. Okay, so as far as what the procedure is, so let's say the employer gets to the point of actually being able to file an H-1B for you. So they've either you've been selected for the CAP, or you're CAP exempt for some reason. The process is entirely driven by the employer. So they're the ones signing off on everything. You don't even actually sign anything. You don't sign any of the paperwork. It's all sort of driven by the employer. And again, employer specific, only applies to that employer and that job. The first thing they have to do is get a prevailing wage. So basically, they go and obtain prevailing wage data from the Department of Labor, which can either be done formally, as in they can make a formal request with the Department of Labor to make a determination. Generally, employers won't do that because it takes like 5 to 7 months to get that back. So that kind of defeats the purpose. But for purposes of an H-1B, they're also able to look at that data themselves, make a determination of how the job fits within the Department of Labor wage data, and pull that prevailing wage data from the Department of Labor. And there are going to be, for every given position, there will be 4 available job or wage levels, depending on the area of employment and the level of experience required, and education and training and things like that will determine whether you use a level, anywhere from a level 1 wage to a level 4 wage for that particular job in that particular location. So that's the first thing they do. And the employer has to state that they will be offering you at least the prevailing wage level for the position as a base wage. So this makes it somewhat difficult for employers that want to hire people mainly on, commission or incentives. They have to actually be offering a base wage that is at least the prevailing wage for that position. And prevailing wages tend to be relatively high. I mean, the idea behind requiring a prevailing wage is sort of to ensure that employers are not undercutting U.S. workers by hiring, foreign workers at a cheaper rate. So basically, they want to make sure that the employer is paying a competitive wage to you, which ends up working out for you too. The next thing that happens is the employer files a labor condition application with the U.S. Department of Labor. This is slightly different than the ALC application for labor certification, which is filed for the green card process, which does require recruitment for the position. That is not required for an H-1B. So frequently employers will think that that's required for an H-1B. It is not. But they do have to file this LCA, which makes certain statements to the Department of Labor. So they're basically saying, we're going to pay the prevailing wage. There's no strike or lockout or union issue with the position. So they make certain attestations to the Department of Labor. It takes them, it's an online filing. It takes 7 days generally for the Department of Labor to process it and come back and say, okay, we approve of that. And the employer also has to make a posting in the job location. They have to actually state either the LCA itself, they have to post that, or else they have to post something that sort of reveals the terms of the LCA, including your salary for everybody to see. So that's always fun. The next thing that has to happen is that once the LCA is approved, then the employer has to file the I-129, which is the USCIS petition, and fees, lots of fees, with USCIS, and they'll also submit a support letter and various documentation that shows that you meet the requirements for the position, your degree, your transcripts, a copy of your passport, things like that. Evidence of your current status. If you're currently employed by them, they may need pay stubs, things like that. So they submit a petition with USCIS, again, with lots of fees, and then USCIS ultimately makes a determination over whether your H-1B is approved or not. If your H-1B is approved, the next time you leave the US after that, you will need a visa, a new visa for process or for reentry. So you'll go to a US consulate in your home country with the approval and the approval package that the attorney will likely put together for you for your appointment, and you'll get a new visa for reentry. But visas, you should always keep in mind, a visa doesn't govern your status. A visa is an entry document. So it's really necessary for travel. But if you filed for a change of status from within the US, so say from OPT to H-1B, and you don't need to leave the country in order to activate your H-1B, your approval notice in that case should have an I-94 on it. And an I-94 is always what governs your status. So that will have the I-94 on it that will say, okay, your position starts on this date, you're valid from this date to this date on H-1B, and then you would only need a visa in terms of re-entry. That is not the case if you were outside of the US when the employer filed for you, then you would need the visa. But if you filed a change of status from within the US, then you only need the visa the next time you travel. So this is just a little more information about that labor condition application. I won't really read through these because you'll fall asleep for sure, but these are the things that Department of Labor is looking for the employer to attest to when they file the labor condition application. So these are the things that the employer is saying to the Department of Labor. So I have mentioned already that H-1Bs are employer specific. So again, they are sponsored by a particular employer. You can't work for anyone else, which when I say that, that means you can't do things on the side that you get paid for. You can't consult or start your own business or do speaking engagements where you get paid. You're really limited to employment and payment from only the company that or employer that sponsored you. H-1Bs are great because probably their best feature is that they allow dual intent. And what that means is that most of the time when you've had, say, J1 or F1 status, almost all non-immigrant or temporary statuses come with the requirement of you having non-immigrant intent, meaning you have an F1 student visa. I'm just going to come here and study, and then I'm going to leave. I have no intention of staying in the US permanently. I'm J1, I'm an exchange visitor. I only intend to come here for my program, and then I'm going to leave. I have no intention of staying here permanently. With H-1Bs, you can have dual intent, which means I'm here to do this job, and I may or may not want to stay here permanently, and that's okay. So okay for you to have immigrant intent. It's okay for you to apply for a green card when you're on this status and to continue to travel while you have a green card pending and to get a new visa while a green card is pending. And all of that is fine because you're allowed to have immigrant intent. So that's one of the main reasons that you'd want to have H-1B status, is ultimately, if you wanted to be sponsored for a green card, it's a very smooth transition. You can maintain your H-1B until you have your green card and live a relatively normal life while that's happening. It is also possible to have multiple concurrent H-1Bs, and H-1Bs don't have to be full-time employment. When you're sponsored for a green card, it does have to be based on employment. Then you have to be sponsored for a permanent full-time position. But for H-1Bs, it doesn't have to be full-time. So it could be part-time. You can have 2, 3 part-time H-1Bs, but they would all have to be filed for separately. So they would require separate filings by each employer, but you can have multiple concurrent H-1Bs. If you are let go from your job, whether you're fired or laid off, there's always the question of whether there's a grace period. In the past, the answer was always no, that you sort of were instantly out of status. That's technically still the case. There is now, though, a discretionary grace period of 60 days if you're laid off, terminated, or resign, to find a new job or file for a change of status. So basically, there was a recent change in the law where they said, okay, yeah, we'll give you like 60 days to figure something else out. If you get let go and you want to file you find some other employer who's willing to file a new petition for you within 60 days, that's reasonable, you can stay. Then they just kind of ruined the whole thing by calling it discretionary, which just means, yes, we're basically allowing this, but we could say no. So I have not actually ever seen them say no, but just keep in mind, that's why I had to use that sad discretionary word, because they do say they have the ability to say no if they want to. And the cost of return transportation. So in the event that your employer let you go and it wasn't your decision to leave, but they terminated your employment in some way, as part of the paperwork that they signed to get you an H-1B, they said they would be responsible for the cost of your return transportation to your home country. That doesn't mean they have to give you cash, and it doesn't mean they have to pay for your dependents, but it does mean that they agreed if you choose to leave. So that is making a big presumption. But if you choose to leave after that and go back to your home country, they did contractually agree to pay for the cost of your ticket. So they should have to pay for that. And just some notes about extensions and changes of status. So an extension of status, so say you're on H-1B and your first 3 years is running out, and so you file to extend your status for the second 3 years. An extension of status can be filed within a 6-month window prior to the expiration of your current status. So you have 6 months there before your status expires where you file, and you do have to file it, of course, prior to your current status's expiration, but it can be right up to the wire. So if you do that, you can work beyond your current expiration of stay for the same employer for 240 days or until a decision is made. So if you file with 3 months left in your H-1B status and you get to the end of that 3 months, so your H-1B is expiring, but your extension is still pending, you can continue working after that for 240 days or until a decision is made. So that's an automatic extension of status. Right now, since it takes so long for them to approve extensions, it's always a good idea to file extensions as early as possible so you can extend that time. And it's fine for you to travel while an extension of status is pending, as long as you still have a valid visa for reentry. So again, let's say you filed 6 months in advance for an extension, so you have 6 months left on your current visa if you've gotten a visa, and then you're gonna leave while that extension is pending, but you're gonna re-enter prior to the end of your current H-1B time. That's fine as long as you have a visa for reentry. A change of status is a little bit different, and it's important to note that, so if you filed like an F1 to H-1B change of status, if you leave the US while a change of status is pending, that will constitute an abandonment of the change of status request. And I do say here that the underlying petition can still be approved. So what that means, let's say you file from your F1, you file for an H-1B, and then while that's pending, you leave the US. Whoops. and they deny the change of status request, they can still approve the H-1B, but they can't issue you a 994. You weren't in the US, so they can't issue you an I-94 right there. So they issue you an approval notice that would require you to go to the consulate and get a new visa for reentry. So it doesn't mean the H-1B itself would be denied. It just means that the change of status request would be denied. And again, that last point, of course, don't work after the expiration of current status if you're waiting for a change of status. Yeah, unless there's CAP or OPT work authorization, which would normally be the case. I assume most people here are probably F1, and then you'll be OPT and have CAP. But if that's not the case, as far as final thoughts, do you need a lawyer? Maybe not. H-1Bs are again, they're really driven by the employer. They're very, very complicated for employers and very intimidating for employers. And one thing that I think you should know is that it's intended to be that way. It's really intended. A lot of the H-1B process, just politically, the way it's developed, it's very punitive to employers. It's really intended to, much of it is intended to punish employers for hiring foreign workers, or to ensure that if they had two workers in hand and one were a US worker and one wouldn't, that there's no way that an employer would choose the foreign national because of the extra hoops and cost that is involved in filing for an H-1B. But it is very onerous on employers. And I would say, yes, the employer definitely needs an attorney to file an H-1B. It's a very difficult process. They definitely need a lawyer. Do you need a lawyer? Probably not. But keep in mind that normally, like if I'm representing an employer who's filing an H-1B for someone, I'm fine with talking with the employees as well. So some companies don't want me to at all. They just want me representing them. Some acknowledge that, okay, the employee has some questions too that they'd like to ask you. And generally speaking, that's how it works, but sometimes it's not. So just keep in mind that if you have questions and you have concerns about the process, you may be able to talk to your employer's attorney, but you may not be comfortable with that because that attorney is primarily representing the employer. And if you think there's any conflict and you want someone that you know is going to answer things with you in mind, as opposed to the employer, usually it doesn't really matter. But if it matters to you, if you have so say you had an issue of like you have some criminal history or something or say you have like a status violation that you might not want your employer to know about, but you want to know how is that going to impact this process, then you might want to seek your own counsel. And just keep in mind that the employer or the attorney who's filing the H-1B is primarily representing the employer. And if you're looking to find a lawyer, you can always use AILA, which is the American Immigration Lawyers Association. Normally, all immigration lawyers are members of AILA. So it's a pretty safe bet that if you're looking for someone, that's a good place to look. And that is the end of my song and dance. So I'm going to stop sharing and go to your questions.
So yeah, there are a couple questions from the same person in the chat, and then I got sent a direct question.
Okay. Want to start with your direct?
Sure. So it is a 2 to 3 part question. So first is there any possibility for a J visa candidate to switch from J to H-1B without a J waiver?
Okay, so for a J candidate, not everyone will be subject to the 2-year home return requirement for a J, but I'm assuming, obviously, in the context of that question, that we're talking about someone who is on a J and is subject to the 2-year home return requirement. And essentially, no, the short answer is no. There are some very minor exceptions, some positions, and some very minor exceptions, but for the most part, no. You cannot switch to H-1B until you have either fulfilled the requirement or obtained a waiver of it.
Okay. Then the second part is it possible without a J waiver that one can change their status, for example, to an O visa?
Generally, no. You can't change your status, but you could file an O visa. The distinction then being that like an O is a temporary visa, so you could get like you could switch to F or you could switch to O, but generally speaking, that you would have to leave the U.S. and get an O1 visa and get an O1 or an F1 and re-enter. So you wouldn't file it as a change of status; you'd file it as the consular process, and then you'd go abroad and change status.
Okay. Yeah, that's
Okay,
the end of
that's
that
it.
one.
Okay,
Yeah.
all right. So yeah, and some of these here are okay. If I'm on L1 and my degree is not related to my job, is it recommended I do master's to increase my chances of an H-1B? Okay, so if you're on L1, first of all, keep in mind that your L1 time will count against H-1B time. So if you have 6 years of eligible H-1B time, but you've spent 2 years in L1, then you're only going to have 4 years of eligible H-1B time. So whatever time you used in L1 will be subtracted from your available H-1B time. And yes, you won't be able to get an H-1B if you if your degree is unrelated to the position. But if you're staying with the same employer, there's no reason that you couldn't just stay on L1. L1, by the way, also allows dual intent. So it's equally attractive, in some cases more attractive for other reasons, in getting a green card. So if you're staying with the same employer, there's really no reason that you need to switch from L1 to H. You can just stay on L1 and that's fine. If you're switching employers, then you won't qualify for L1 because it's based on a particular relationship with your previous employer. So then you would need to, yeah. So then if your degree was unrelated to the H-1B position you're applying for, yes, a master's degree would probably increase your chances. And the next question is, if we have multiple H-1Bs, does the 6-year period work independently for each H-1B or just everything in general? The 6 years is for everybody. So if you work 2 years with one employer and then switch to a new employer, you don't get a whole new 6 years. You only have 4 years left. So that's a general clock that applies to all of your combined employers. So if someone is here on a J1 visa subject to the 2-year rule and applied for a waiver and is planning to switch to H-1B in an academic role, in the meantime, I would like to apply for a green card. To apply for a green card, should I wait until I get H-1B? That's a really nuanced question that depends on a lot of circumstances that aren't stated here. So it's a little difficult to answer in a general way, and I can't get into specifics of someone's particular situation. But I would say in general, you can start the green card process if you're not on H1, H1B, but it does complicate things. There are certain periods of time, for instance, after the I-140 is filed, then you've established that you have immigrant intent. So if you have like J1 status or F1 status and you get to that point, it's a little messy because you're in a status that requires non-immigrant intent, and now you've established that you in fact do have immigrant intent. So it gets a little messy in terms of traveling and changing status and extending status and all of that. So that's why it's generally, you can, some people will start the green card process, particularly if it's a labor certification based process. You can certainly start it while you're outside the US or while you're on a different status. But by the time you get to that I-140 stage, that's where it gets messy. That's kind of my general answer to that. Is it correct to think that you only need to pass one cap lottery in your entire H-1B time? Yes, that is correct. That is correct. Once you've gotten through the cap once, then if you subsequently change employers, you will not be subject to the cap again. And the recordings, yes, are shared with you.
Yes. I'll just add real quick that the slides are already available on the website. I'll share the link again, and just in case those who attended late, the links to the slides today are available on the international. Oops, I sent that directly to someone. Sorry about that. Right here, the slides are available, and that's where the recording will also be available. But after a Zoom recording, it does take a little bit of time for that recording to process. So I would give me like a day or two to get that recording on the website, and then they'll both be available on that link I just shared.
Yep. And the other one is specific to the person's circumstance. So I'm not going to address that directly, but just in general, yes, your degree has to just, the important takeaway there is that your degree does have to be directly related to the position that's being offered. Sometimes MBAs are a little troublesome because MBAs can be just general, or they can be like in finance or in, and sometimes USCIS likes to see that's very specifically directly related to the position that's being offered. So that's important takeaway is, yes, your position, whatever level of degree you have, whether it be master's or PhD or bachelor's, it has to be directly related to the position that you're being offered.
I did receive another private question or direct question.
Okay.
During the 30-day grace period, can a J1 visa candidate change their status to an H-1B or O visa or even another J visa?
I'm sorry, I missed the beginning of that.
During a 30-day
During a grace period. Yeah, you can file for a change of, you can generally consider that as status. It's not technically status, but for purposes of filing an extension or change of status, you can do that within the grace period. Yeah, you cannot continue to work though during the grace period. And general suggestions on choosing an immigration lawyer on AILA. Yeah, AILA does have an attorney referral service on there, but it's really just a matter of whether, like, I don't participate in that anymore. So and a lot of attorneys don't. So it does give you sort of a good look at, it allows you to see who's in your area, and then you can sort of independently look at those attorneys on AVO or some other rating system. AVVO is, an attorney rating system. Martindale Hubble is kind of probably a little outdated, but that's another one. Or the best thing to do is probably to ask around, ask the International Center, ask the other people who have been through similar processes. That's probably the best way to find an attorney, is really through word of mouth. I don't really understand this question, but how do you think about H-1B abuse? I don't really know what's being referred to there in terms of H-1B abuse. I don't really know what that means. I don't know what that person's asking about, but feel free to clarify if you want. But other than that, I think that's all of the questions. Did I miss any?
No, I think that covers all of them. So yeah, we have just a couple minutes left. So if anyone has any last minute questions or clarifying questions, now is the perfect time.
Everyone's sleeping. Yeah, sorry guys. I know it's not like the most exciting topic in the world. But next week, probably a little easier to understand, I think. Oh, that is a good one. Any suggestion on how to approach the employer asking for H-1B? That is a really good question, and it's a tough one, I think. I think when you're working with sort of large employers, who have done this before, it's really not an issue. And I think employers are becoming more willing. I mean, with less qualified US workers who are educated in the marketplace, I mean, I think employers are becoming more willing to do this. But a lot of times they do experience a bit of shock as to which is intended by the government, once they see what the process is. So I think probably the best way to do that is to sort of, if you know that you're applying for a job with an employer who has never done an H-1B, one good thing to do is probably to talk to an attorney in advance and say, hey, can the employer call you? Can they talk to you? So that you at least have a resource available for them. because a lot of employers will say, well, I don't know how to do that. Like, I'm willing to do it, but you got to handle it. I don't want to, I'll sign whatever you want. No, you can't be put in that position. That's not allowed. They have to actually handle certain portions of the process, and they can't have you involved as their attorney, so it's probably helpful if you have, say, hey, I know this attorney does H-1Bs. I'm sure they'd be happy to share information with you, or look on the USCIS website and get some resources for them so that they kind of know what they're getting into. But it's probably in your best interest just to be straightforward about it. You can essentially conceal the information because there's things employers can and can't ask you, or at least have you prove prior to employment. So it may not come to their attention that you need H-1B sponsorship. But I think it's in your best interest if they know that straight off the bat and are willing to sponsor you and undertake that. Yeah, now there's questions coming in. should we cut it off? Yeah, I don't know.
Yeah. Well, I get one is quick. Can we write you an email if we would like to consult with you?
Oh, yeah, absolutely.
Okay.
Feel free to email me. My website is listed on the slides that are posted with the International Center, and you can submit an inquiry there, or you can email, or my email address is also listed. They both go to me. So,
and then we'll just do this one more question. Do you recommend to do OPT first and ask for H-1B, or directly ask for H-1B?
Either is fine. You can go. It's just that as a practicality, you're generally on OPT first, right? Because you're generally done with once you're done. It takes some time to get through the H-1B process, and you have to have your degree in hand before you apply for an H-1B. You have to be completely done with your degree. Unless, say, you're in a master's degree program and you already have a bachelor's degree and you're just, then that's fine. You can just switch directly. But normally, as a practical matter, you'd be an OPT, but you don't have to be. That's fine to go direct. It just gives you work authorization while you're, waiting.
All right. Well, thank you, Dawn. I'll stop recording right now.